Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. As the year draws to a close, we're taking a look back at the biggest employment law stories. We caught up with Epstein Becker Green attorneys at the firm's annual workforce management briefing to find out what defined 2025 in their practices. One word stood out beyond all others.
Change.
Things are changing.
Changes in regulations.
The change in priorities.
Things are changing at such a rapid pace.
Changes in AI regulations, continual change within the restrictive covenant space.
Changes in Colorado.
Shift in legislation.
Change the landscape for many employers.
Change on hold.
Change was, of course, the word on everyone's mind in 2025. The year began with a new administration that made it a priority to shake things up, beginning with the federal workforce.
Well, for me, I came from the Department of Justice after 24 and a half years, so it has to be the downsizing of the federal government and the change in priorities of the Trump administration.
The president has also asserted the authority to fire Senate-confirmed members of several multi-member agencies, including the FTC and the NLRB. That kind of change has, at times, led to rapid shifts in policies. In other instances, it has had different results.
This year, we've seen a significant delay in the change that the Trump administration would likely bring in regulation at the National Labor Relations Board, largely due to the delay in getting the president's nominees to fill vacancies through the Senate. So there has been a lack of NLRB quorum from board members this year. We've also had an acting general counsel. And so that's just delayed some of the policy making that we would expect when a new administration comes in.
While the firing of board members at the NLRB and other agencies triggered court battles and delays, the new administration was able to make immediate and significant changes to how the federal government regulates diversity, equity, and inclusion.
Clients have historically focused on DEI efforts and really wanting to create a diverse workforce, and now it's potentially a risk. So we're seeing rollbacks of DEI programs, modifying policies, eliminating chief DEI roles, and examining things just like basic DEI trainings. There have been cases where they're alleging that that's creating a hostile work environment.
In an effort to eliminate DEI, the Justice Department has reversed many anti-discrimination provisions. Just this month, the DOJ ended the use of disparate impact analysis in discrimination suits under the Civil Rights Act. As a result of these moves, our attorneys are seeing a new sort of discrimination action emerge.
The increase in reverse discrimination suits and reverse discrimination actions. So we're so used to thinking of it as a tool for certain groups to use to talk about their experiences in the workplace, but now it's being used by majority groups.
Immigration is another area employers have experienced big changes, including a rapid escalation in federal enforcement.
With the focus that the administration has placed in that space, we're now getting a lot more questions. We're getting requests for training, I-9 audits. What happens if ICE shows up?
A lot of employers are shutting down their use of immigrant labor, trying to figure out how they're going to staff certain skilled positions without having to go through the H-1B visa process.
In 2024, the FTC proposed a nationwide ban on non-competes, promising to reshape the law around restrictive covenants. But by 2025, we began to see a big shift towards state regulation.
We went from what looked like to be a nationwide ban on non-compete agreements all the way now to Florida's Choice Act, where you could have up to 4-year non-compete.
The Trump administration also rolled back the executive order that Biden put in place in 2021 concerning competition. So there was a lot of change on the federal level. On the state level, there were over half a dozen states that passed legislation restricting non-competes in the healthcare space itself.
At the state and local level, we have seen significant change in all areas of employment law. Some coming in response to federal changes, and some addressing larger trends, such as paid leave and AI.
Clients are keeping up with all of the different jurisdictions across the U.S., dealing with new paid family medical leave laws, paid prenatal leave, paid sick leave, paid leave for any reason.
The president signed an executive order that did away with the Biden-era AI executive order and has really pressed forward with innovation and deregulation in the AI space. And that has trickled down to the state level, and we've started to see more movement in the state legislatures to try to fill that void that's been left by the federal government.
State-level AI regulations, particularly in Colorado and California, captured headlines in 2025. They also drew the ire of the federal government. This month, the president signed a new executive order instructing the Justice Department to sue states that attempt to introduce their own AI regulations. But for employers, AI is having an even bigger impact on internal dynamics.
We're already starting to see it permeate different areas of labor and employment law, from how you interact with your workforce to how you review your workforce and even how you create your workforce. So it's going to be important to embrace it and evolve with it.
We've seen now a balance between employers wishing to institute AI on an enterprise level and employees that are looking to use different forms of AI in their day-to-day activities.
Amid all this change, I asked my partners at Epstein Becker Green how employers should respond. Their answer? Stay nimble and stay up to date.
Employers have to stay informed and be flexible because things are changing at such a rapid pace.
We saw an unprecedented amount of change this year from the new administration, and we have to be on our toes to see what will be coming next.
Thanks to all my colleagues, and a very special thank you to all of our viewers. We'll be back every week in the new year to help keep you informed about all the changes that 2026 has in store for us. Happy holidays.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.